Hello, everyone, and welcome to this presentation on asset protection planning and bankruptcy. Today, your speakers will be Stephen Fox, a good friend of mine. I've known Stephen for many, many years, and Stephen is an amazing bankruptcy attorney, probably one of the best-known bankruptcy lawyers in the state of California. I worked with Stephen on a number of cases, and he is very knowledgeable, very likable, and he will deliver a great presentation today on how asset protection structures fare in the context of bankruptcy and the kind of things we need to look to do to make sure that we succeed when our asset protection clients do file for bankruptcy one day. But before Stephen gets a chance to speak, I'm going to speak for a few minutes on asset protection planning in general. So we do have lots of participants on this call. We have, I think, well over 100 participants attending. You are all very welcome to ask questions of us. You have the Q&A panel, and you guys are welcome to ask questions as we're speaking. You're welcome to ask questions at the end of this presentation, or at any point in time thereafter. You can always email questions to me or to Stephen. You have our contact information. You also can see them on our slides. Let's get started on that note. So I'm Jacob Stein, and I am an attorney practicing in Los Angeles, and I am probably best known for my asset protection practice. I think our asset protection practice is likely the largest one this side of New York City. I've been doing this for nearly 20 years. I have completed over 3,000 asset protection transactions, and I have seen it all and I've done it all. I've taught many asset protection presentations, and I'm sure a number of you have attended my presentations in the past. And I thought it would be kind of more interesting to do a presentation that speaks not only to asset protection, but what happens in the context of bankruptcy and how do asset protection structures fare in bankruptcy. As Stephen will explain in a lot more detail, the bankruptcy world is very different from the world that I live in, which is the world of state law and state courts. So for asset protection planning in general, we are dealing with debtor-creditor laws that are found in the state statutes. So we may be looking at the statutes that deal with collection of judgments. We may be looking at statutes that deal with enforcement of liens and levies. And we may be looking at exemption statutes, right? Certain assets are exempt under state law. When we engage in asset protection planning for a client, what is our objective? And I will tell you that our objective is not to protect assets, despite the name of this area of the law. Protecting assets, at least in a foolproof, sort of bulletproof way, is usually a dream that's not attainable. Because we cannot protect assets in a foolproof way. What is the goal? Well, the goal is to make assets a lot more difficult and a lot more expensive to reach, to change the plaintiff's economic analysis of the case, right? To make them realize that the debtor, our client, is going to fight hard to keep his assets, that the creditor may have a very difficult time reaching the debtor's assets, and they may end up spending lots of time and lots of money pursuing the assets, and maybe one day they will be successful in those pursuits, and maybe they will not be, right? So create that uncertainty and make them understand that there's a cost, a significant cost that goes with uncertainty, and force them to come to the negotiating table. So of the 3,000 or so cases that I handled over the years, the statistics are as follows. And please bear in mind that we are lawyers, we're not statisticians. The statistics are, I guess, somewhat accurate, but not too far off because it is a huge number of cases that we have handled. So our statistics tell us that, at least outside of bankruptcy, I guess in bankruptcy things change, but outside of bankruptcy, when a creditor is confronted with an asset protection structure, about 30% of the time they simply walk away. They just walk away from the debtor. They do not try to pursue the debtor's assets. They do not try to do anything with our structures. They just walk away. Of the remaining 70% of cases, the vast majority of the time, like 98% of the time or so, the parties settle. Settle now on terms that are a lot more favorable to our clients, right? So our clients are able to settle for a lot less than they would have been able to settle for without the asset protection structures. In 1 to 2% of cases, tops 1 to 2% of cases, do we see creditors try to penetrate the structures we have set up? And sometimes they are successful, and sometimes they are not successful. So statistically speaking, asset protection works really well. And I am of a firm mindset that asset protection is very much a practical art and not a science. You will hear a lot of people talk about things like fraudulent transfers, specific types of structures to protect assets. And that's all well and good, but at the end of the day, it's this kind of very simple analysis of will the plaintiff think it is worth their while economically to pursue our clients' assets and try to get through the structures we have set up. Obviously, there are exceptions, right? To every case, there are exceptions. For example, sometimes our clients will be confronted by a creditor that has an emotional stake in going after a client, like perhaps a former spouse or a former business partner, or someone who feels that they were wronged in such a way that they must right that wrong, and it doesn't matter how much it costs to do so, right? So that's not about money anymore. That's now about emotions, and as we all know, emotions are expensive for both sides. Sometimes our clients are pursued by large government agencies, and they may not care how much money they spend because the government bureaucrats who are handling these cases are not spending their own money, right? And then the analysis is a little bit different. Well, so sorry, and a question came up. Are there handouts to download for the seminar? Yes, there are. There are downloads. Available, and if you have not received it, we will email you the materials. And someone else said the slides are not advancing. Well, that's because I haven't gotten to the point where I will be advancing the slides. Okay, and I guess on that note, let's move forward. So in asset protection in general, there are about, in our practice, I would say there are a couple dozen structures that we commonly use to protect assets. None of them are right, none of them are wrong. Different structures are called for under different circumstances. So perhaps depending on how risk averse our client is, the debtor, what is he willing and prepared to do to protect his assets? Depending on the timing of the claim against our client. Are we representing a debtor? We are representing a debtor in the context of a pending case, like there's already litigation taking place, or the judgment has been entered, or some sort of a tort has already occurred, or are we engaging in asset protection planning on a prospective basis? Who is the creditor coming after our client? Is this, for example, a government agency that is generally very scary to contemplate, but maybe it's a huge bureaucracy and they do not very forcefully pursue collection efforts on the judgment? Is it a plaintiff's attorney who maybe is a brilliant litigator and will get a large judgment against our client, but doesn't really know how to collect on the judgment because that's not his expertise? Is it a former spouse, which is probably likely the most formidable creditor out there? So who is this creditor? We definitely need to take this into account and how aggressive, intelligent, well-funded they are and so forth. And then the final inquiry we'll look to is what are the nature of the assets that we need to protect? Are we protecting a personal residence? Are we protecting a professional practice, money in the banks and sort of a retirement plan? So putting all of these factors together, right, we come up with a number of options for our clients that we recommend to them. These are the things you can do to protect your residence. Here are the things you can do to protect, let's say, money in the bank. And different clients will pick different options, right? Some of them may be risk averse by nature. Some of them may be risk takers. Some of them may have gone through litigation before and know that it's scary and don't want to do this again and really want to protect their assets well. Others may have gone through litigation, prevailed easily, and are not worried about it. So one of the bigger obstacles in asset protection is the law of fraudulent transfers. And this is something that I think Stephen will speak a bit more in the context of bankruptcy. So I will speak to fraudulent transfers outside of bankruptcy, how it works in practice. And I'm not going to get into how fraudulent transfer laws work. Perhaps Stephen will spend a few minutes on this. And I've taught other much longer seminars on this topic specifically. But let's assume that we are engaging in last-minute asset protection planning, meaning an accident has already taken place, or our client has already defaulted on a loan to a lender, or a lawsuit of some nature has been filed against him, or some government agency launched an investigation or send them a letter, right? So we're already acting after someone has a cause of action against our client, right? Someone has a claim against our client, and now our client has an existing creditor. Once you have an existing creditor, any transfers you engage in to protect your assets may be challenged, and they may be voidable as a fraudulent transfer. And to a lot of attorneys, this term fraudulent transfer is a scary term, right? Because the first 5 letters are something we do not want to associate with, right? None of us want to engage in fraud, encourage our clients to engage in fraud, or somehow assist them in engaging in fraud. So in fraud certainly can be a type of a fraudulent transfer, but by and large, a fraudulent transfer has nothing to do with fraud, right? A fraudulent transfer is a term of art, and it relates to a specific set of circumstances and very specific transfers. So without getting into the specifics of what makes a transfer a fraudulent transfer, I want to focus right now on the practical aspects of a transfer that may be deemed fraudulent, meaning, is this something we should be scared of? If we expect that a plaintiff will challenge what we have done as a fraudulent transfer, and if we expect them to be successful, does that mean we should do nothing? I will share with you one of my favorite client stories. So my client, in this case, she was about 72, 73 years old when she came to me. And she came to me with the following story. Her son was about, I think, 40 years old at the time, decided to become a real estate developer. He's never been a real estate developer in his life. As a matter of fact, he's never done anything in his life other than sit on the sofa and watch TV. But everyone was making money in real estate, and he has probably seen some reality TV shows on flipping real estate and making money. So he decided to become a real estate developer. And he went to a very large bank and successfully borrowed $5 million on mommy's personal guarantee. It's a real case. So when he borrowed $5 million, mama had an estate of about $8 million. Everything was invested in the stock market. The son was a real estate developer for a glorious 3 years or so. After 3 years, all of the projects tanked, and he walked away. He had no assets of his own. He had no skin in the game. He just walked away, and the bank never even considered, I think, to pursuing him. In the meantime, mommy's stock portfolio declined from $8 million to about $5 million. She made some poor choices. So now she has about $5 million worth of assets, and she owes the bank probably close to $6 million with interest and penalties and legal fees and what have you. So she goes to a few law firms. I think this was in New York. What do I do? And every law firm in New York say to her, well, it's too late to do anything now. There's already been a default on the loan. You have a personal guarantee in place. Whatever you do now will be a fraudulent transfer. It's too late. We cannot help. Let's explore whether that is true. From her point of view, and looking at this for now purely from her point of view, right? So not from your point of view as an attorney, but from her point of view. She has a binary choice. She can choose to follow the advice of these New York law firms and do nothing. And if she chooses to do nothing, what happens? Well, if she chooses to do nothing, it has, I guess, the benefit that that's really easy to implement. But if she chooses to do nothing, the downside is that once the bank gets a judgment against her, the likelihood that she will lose everything that she has is about 100%. Which should be fairly scary, right, for someone who's in their mid-70s, right? So she chooses to do nothing. There's about 100% chance that she will lose everything that she has. If she does something to protect her assets, whatever that may be, if she does something to protect her assets, maybe the bank will challenge that as a fraudulent transfer because they don't bring that challenge in every single case. And again, as I told you earlier, in my own practice, I see that challenge come up in maybe 1 to 2% of cases. If the bank does challenge what she has done as a fraudulent transfer, maybe they are successful, because obviously creditors are not successful in these challenges 100% of the time. And even if they are successful, what happens? Well, the remedy for a fraudulent transfer, the kind of the standard general remedy, is to void the transfer, to recover the transferred assets. It's technically a lawsuit against the transferee, not a lawsuit against my client. Now, I'm going to be very curious to hear what Stephen will share with us, because I'm sure in the context of bankruptcy, his view of fraudulent transfers is very different, and how it works out is very different. Because you have a very different creditor in bankruptcy looking at this. You have the bankruptcy trustee. But outside of bankruptcy, yes, this may be a fraudulent transfer. And the creditor may challenge that. And if they challenge it, maybe they will reach the assets. But that's a lot of maybes. Whereas on the other hand, 100% chance she will lose everything that she has. So very often, from a client's point of view, there is no downside to trying to protect their assets, because the worst that can happen is it ain't gonna work. You know, she's gonna lose all of her assets anyway. Even the legal fees she pays us to protect her assets are not a downside, because she would have lost it anyway. So that's outside of bankruptcy, right? We are aware of fraudulent transfers. We certainly want to structure what we do in such a way so that it would not be deemed a fraudulent transfer. We certainly want to do our structures in such a way so that, for example, we are transferring assets in exchange for fair market value to make it as difficult as possible for a plaintiff to prove a fraudulent transfer. But at the same time, we're not losing sleep over it. You know, it is what it is. We cannot change the facts. We cannot go back in time and have our client engage in asset protection planning before that accident, before the default. And you do the best that you can, right, given the circumstances. There's no magic wand, usually. The kinds of structures that we look at, there are many, as I said, but there are some kind of fundamental foundational structures, and I'm going to ask Stephen when he is discussing this in the context of bankruptcy to share with us how he sees these structures work in bankruptcy. So one of the structures we use frequently would be a limited liability company. Under state law, your membership interest in a limited liability company is not attachable by a creditor. The only remedy that is available to a creditor of an LLC member is a lien against the distributions, which works kind of like a wage garnishment. If the LLC makes a distribution, the money now must go to a creditor. If the LLC does not make the distribution, the creditor gets nothing. And if our client controls the LLC, he will choose to not make the distribution, and the creditor gets nothing. So outside of bankruptcy, LLCs and the so-called charging order protection that the LLC affords us works fairly well. It's not a magic wand. It doesn't work 100% of the time. A creditor may successfully challenge an LLC on alter ego grounds. They may try to argue to the judge that the charging order protection for some reason should not apply, maybe out of equity interests. But outside of bankruptcy, LLCs work fairly well. And given how simple and inexpensive they are to set up, I think LLCs are a wonderful asset protection play. Other than LLCs, what else do we have? Well, we very frequently will use trusts. And we use not any kind of a trust, we use irrevocable trusts with certain specific provisions drafted into them, like it's usually an irrevocable trust with the spendthrift provision. The trustee is given discretion to make distributions, and there is a third-party beneficiary. I do not believe in the so-called self-settled trusts, at least not in California. I don't believe in self-settled trusts. So, for example, when our client sets up a trust, an irrevocable trust, it will be not for his benefit, but let's say for the benefit of his children, and not for his own benefit. And as Stephen will explain later on in the context of bankruptcy, an irrevocable spendthrift trust has a 10-year look back on transfers of assets to such a trust, so we want to avoid that. And then the other structure that we see very frequently would be some sort of an offshore structure. This may be an offshore trust, it may be an offshore LLC, but usually will involve some sort of an offshore legal structure with the money going overseas as well. And this is probably the one time where we can tell our client that, you know, your money is pretty much unreachable by creditor claims. Well, at least with like 99.9% certainty. I don't know if anything works with 100% certainty. And certainly as a lawyer, I'm reluctant to say so. But offshore structures, in my experience, work exceptionally well. And I will tell you that in my entire practice, and I've set up, I don't know how many hundreds of offshore structures, maybe 500, 600, I'm guessing, I have never once have I seen a creditor challenge an offshore structure. Never once have I seen the creditor try to reach the assets that we have or our client has placed into an offshore structure. Now, that doesn't mean that that's impossible. It doesn't mean it will not happen tomorrow and happen successfully. Maybe, anything is possible. But statistically speaking, the odds of that happening are very, very remote. So I have become over the years a big believer in offshore structures. But I also will tell you that their usefulness is somewhat limited because these structures work really well only for liquid assets, and they do not work so well for assets that are not liquid. For example, this office building that I am sitting in, well, we can transfer title of this office building to an offshore trust, but would a California judge care about that if he is really, hot to transfer this building to our client's creditor? Probably not, right? He can probably sign a judicial deed and he doesn't care about the structure we've set up. But once the assets are overseas and the judge here in California or in the United States has no jurisdiction over those assets, once the control over the assets has shifted to someone overseas, in my experience, that's a very nice, very protective structure. So this is sort of a brief overview of asset protection. And what I've tried to do is sort of highlight the keys that I think will be relevant for Stephen's discussion in the bankruptcy context. How do these structures work in the context of bankruptcy? If there is a fraudulent transfer, what is the likelihood that the bankruptcy trustee will raise that argument and raise it successfully? And then what happens with asset protection structures once they get tested in bankruptcy and are found lacking in some way? So Stephen, if you're ready, we will be happy to hear from you. And I'm going to stop sharing my slides so you can share yours.
Let's see. Good morning, everybody, and I hope everyone can hear me. I'm Stephen Fox. I'm an attorney in Encino in the Los Angeles area of California, and I do bankruptcy work. Actually, I do only bankruptcy work, both locally and nationally. I do it through my corporation, the Fox Law Corporation, and that's what this slide is about. Let me take you over to slide number 2. You can see a picture of two twins there. And those two twins really represent the twin principles of bankruptcy. There are two concepts in bankruptcy that matter. One, the debtor wants to get a discharge. The debtor wants to get a forgiveness of all debt, or alternatively, through a payment plan in chapters 11 or 13, the debtor wants to pay the debt out, maybe in full, maybe in part, and then get the discharge. That's the first concept, the discharge or the payment. The second concept is, to the extent that the debtor's bankruptcy estate has any assets of value that a trustee can take from those, that a trustee can take and liquidate, reduce to money, the trustee's going to do that. The trustee's going to take the assets. And we'll cover some of the protections as we go along. But again, as I talk today, those are the two concepts that in one way or another I'm going to be coming back to. Those are the two concepts that underlie what bankruptcy is about. And those are the two concepts that underlie what our bankruptcy rules and what our bankruptcy code all base their sometimes strange choices on. And judges as well in the bankruptcy courts also recognize that these are the two prime purposes of bankruptcy. I want to diverge a little bit. Stay with the slide for a minute because Jacob did raise some interesting points. One, how are LLC interests treated in bankruptcy? How are trusts, in particular, irrevocable trusts, treated in bankruptcy? And then third, how are offshore trusts treated in bankruptcy? And I just want to go sideways for a minute to go to those 3 points that he raised. Go back to the twin concepts and go to the second one, which is liquidation of assets. The bankruptcy trustee is looking to liquidate assets, to make money, to pay a dividend to the creditor body. And Jacob is right. An interest that a debtor has in an LLC is what goes into the bankruptcy estate, and that is what the bankruptcy trustee will be looking at. The bankruptcy trustee cannot force payments out of an LLC, cannot force liquidation of an LLC, provided that the LLC has been formed by someone like Jacob who knows what he's doing, so that mistakes aren't made. Instead, you have to watch out for in LLCs that they can be pierced. And you want to watch out for that kind of piercing. Then let's move on quickly to trusts because I'm still going sideways. Yes, irrevocable trusts, not revocable trusts. A revocable trust is reachable by a bankruptcy trustee as though the trust document never existed. But there is a provision in the bankruptcy code, and we'll get to it, that limits the practical use of irrevocable trusts for a 10-year period after the assets have been moved into the irrevocable trust. Finally, with offshore trusts, they are wonderful in terms of bankruptcy, but the trustee in bankruptcy has control over the debtor, and the debtor's discharge is at stake, or other bad things can happen to the debtor. And that's the main problem that I see with offshore trust. It has to be carefully planned. You start with the asset protection attorney, you bring in a bankruptcy lawyer, and you talk about what can happen, what may happen, and what's going to happen down the road to figure out your timing on everything. All right, let's go to some basics. First, Chapter 7. Chapter 7 is the most common form of bankruptcy. Maybe 95%, maybe 90% of all bankruptcies that are filed in Chapter 7. Chapter 7 is a liquidation chapter. The debtor gets a discharge, the trustee gets to look for assets. In most Chapter 7 cases, there are no assets, but those aren't the cases we're talking about today. Today we're talking about the cases where there has been asset protection work. So let's go over to asset protection. The use of Chapter 7, the liquidation chapter, as a form of asset protection is limited in part because the trustee can sit on the head of the debtor to force things to happen where that's possible. But on the other hand, with proper work to set up the asset protection devices such as the trusts or the LLCs, the debtor's assets can go through the bankruptcy without the trustee being able to get to them. Let's see, let's talk about Chapter 11 and Chapter 13. There's a little bit more room for asset protection in reorganization chapters, and I'm going to come to that. Chapter 11 and Chapter 13 are payment plan bankruptcies. In Chapter 11, the debtor remains in control. He or she or it is known as the debtor in possession. And while he, she, or it has fiduciary obligations to the creditors of the estate, of the bankruptcy estate, what's really neat about Chapter 11 is that the Chapter 11 debtor doesn't have a strong incentive to go and break up the asset protection devices that he has created. He can explain why perhaps it is cost ineffective to go after them, or something else. You have a little bit more breathing room in Chapter 11. Chapter 13 is for individuals only, while Chapter 11 can be for individuals and businesses. Chapter 13, the debt ceiling for secured debt and unsecured debt is a bit low, probably for our purposes, but I just want to point out in Chapter 13 that one of the benefits is, again, there is no real trustee like there is in Chapter 7 who's going to sue and go after asset protection devices. There is a bookkeeper type Chapter 13, the Chapter 13 trustee, but he or she doesn't really investigate, and they usually aren't going to understand asset protection devices. So let's see, in Chapter 11 and Chapter 13, the benefits. The debtor retains the control and the use of all the assets. The creditors don't obtain any of the assets unless the debtor so chooses. The debtor can explain why in his, her, or its plan, why going after the asset protection device is not possible, or is not feasible, or is just too cost ineffective. And then it's the debtor who sets up the plan and figures out how much to pay. Now, one of the downsides of Chapter 11 is that the creditors have to vote to accept the plan, and that's outside the scope of this presentation, but there are ways to work with that. Okay, now, what are some of the chokeholds on a debtor in bankruptcy where maybe there are assets in asset protection devices that are beyond the control of easy to get or even hard to get by creditors. First, Section 523 of the Bankruptcy Code says that individual creditors may object to the dischargeability, to the forgiveness of their specific debts or claims against the debtor. And there is a list of maybe about 19 or so subsections under 523A that talk about all sorts of different objections. Suffice it to say here that if a debtor has committed an act of fraud against a creditor and a claim arises as a result, if a debtor has committed fraud or defalcation while acting as a fiduciary, think in terms of a fiduciary of a trust or of another asset protection device, if a creditor has committed what is called a willful and malicious injury to another person, a creditor, or to the creditor's property, those are debts whose discharge can be blocked in bankruptcy. By the way, Section 523A has some interesting subsections on what can be blocked from discharge. The first three I've mentioned, fraud or defalcation while acting as a fiduciary or willful and malicious injury, those are fairly straightforward in the sense that they have to be dealt with inside the bankruptcy court, typically in the first 90 days or so of the bankruptcy case. But there's some other subsections of Section 523A that can be raised at any time. One of them is whether a claim owed to a former spouse or to a child is in the nature of, if it's in the nature of spousal support or a property settlement, those can be blocked, and those can be blocked from a discharge. Don't be afraid of those. Those might be some sort of, there might be an opportunity there working with a former spouse to use it to gain some leverage over other creditors. There's also section 523A11. It's fraud or defalcation with respect to a depository institution or an insured credit union. If the debtor is acting as a fiduciary, a bank or a credit union may bring an objection to the discharge, and they can bring it pretty much at any time. One quick example, in one case, the National Credit Union Administrative Board sued a debtor, and requested that a debt be non-dischargeable. And the NCUAB alleged that the debtor, while acting as a director of a credit union, had participated in fraudulent schemes, which violated both state and federal statutes. Debt held non-dischargeable. Other commitments to a federally depository institution can be held non-dischargeable. And this is something which may be good, may not be good. Debts owed by a debtor to the debtor's pension plan may be held non-dischargeable as well. There's also not only section 523 that can be used against a debtor, there's section 727 of the Bankruptcy Code. And this statute basically says the court shall grant the debtor a discharge unless the debtor has done certain bad things. The debtor's acting with bad intent has transferred, removed, destroyed property of the debtor, records of the debtor, has made a false oath. And let's just take a moment just to go back and to look at one item. The debtor with intent to hinder, delay, or defraud, and this is section 727A2, has transferred, removed, destroyed, mutilated, concealed property of the debtor within 1 year before the bankruptcy is filed. All right, this is a real simple one. You transfer assets to an offshore trust in the 1 year before you file a bankruptcy, you've got a problem. You've given the creditors or a bankruptcy trustee a dead bang winner to go after the debtor's discharge of all debts, not just one debt, but all debts. So practice point number one, don't transfer assets to an offshore trust. Don't transfer assets even to an LLC or to a corporation or to an irrevocable trust in the 1 year before filing a bankruptcy. That is, unless it's done with great planning, and even then it's probably going to be very difficult. Section 727A has a whole bunch of different exceptions to the discharge. Let's talk a little bit about Section 727 and asset protection. The purpose of filing a bankruptcy for the debtor is to get a discharge, is to walk away from debts. And debtors who own valuable assets or maybe have done extensive pre-bankruptcy planning to protect their assets, they may feel the urge to conceal, they may feel the urge to destroy records or to make a false oath. And the question I would have to them is, why, if you've done all this planning, would you want to risk everything by lying on your bankruptcy papers? It just doesn't make sense. If you've taken the trouble to do asset protection, serious asset protection with someone like Jacob Stein, yes, you can go through a bankruptcy and you can disclose what is appropriate and necessary and legitimate to disclose, and you can generally take those assets through the bankruptcy case and hang on to them. So those are my comments on Section 727. And we're going next to something that, I'm sorry, may start to feel a bit boring to everyone, but it's important. It's important in terms of what a trustee can reach. and it's section 541 of the Bankruptcy Code. 541 creates an estate, a bankruptcy estate. In section 541, well, let me back up. Assume that everything a debtor owns is part of the bankruptcy estate. Not necessarily true, but assume that. 541A says, if there's a case, the bankruptcy estate is created and it holds all legal and all equitable interest of a debtor in property as of the date the bankruptcy case begins. That's scary stuff. It's hard to get broader than all legal and all equitable interests of a debtor. It just is hard to get any broader than that. However, section 541B says, however, the following property is not property of the bankruptcy estate. And it's a lengthy list. Let's just cover a couple of items. Under 541B1, any power that the debtor may exercise solely for the benefit of an entity other than the debtor. Okay, we're talking about the debtor acting as a trustee of a trust. We're talking about a debtor acting as the manager of an LLC. That may be relevant. If a debtor has placed funds in an educational IRA, and if certain requirements are met, those monies do not go into the bankruptcy estate. If a debtor has placed funds, if a debtor has used funds to purchase a tuition credit, also really dealing with educational monies, those too do not go into the bankruptcy estate. In my experience, what is the most important thing to do when it comes to what goes into the bankruptcy estate is to meet early with the client and with the asset protection attorney and jointly work through what are the assets that would go into a bankruptcy estate and what are the assets that would not. Figure out how to move as many of the assets that would go into the bankruptcy estate over to the column of assets that won't go into the bankruptcy estate. You have a wonderful opportunity if you've got a year or two to set aside monies into retirement accounts, into health plans. You can do all sorts of interesting little things just to deplete your own assets before you file a bankruptcy. Now another one, and let's see, maybe it's going to be another slide. Yeah, we'll go on to the next slide. We'll change the picture a little bit. Briefly, all I want to mention here are spendthrift trusts. Spendthrift trusts are a really neat device, and for bankruptcy trustees and for creditors, they are extremely frustrating. If your trust has a spendthrift trust provision in it, basically a provision that restricts or conditions transfers, under 541, the right to receive the monies to a debtor or the properties to a debtor under spendthrift trust don't go into, I shouldn't say don't go into the bankruptcy estate, but more importantly, that provision is enforceable in a bankruptcy case. So if there's a spendthrift trust, then the bankruptcy trustee and creditors in bankruptcy cannot get to those assets. And that's perfect. I'm going to mention section 522 of the Bankruptcy Code just to tell you this. It's a really complicated statute in the Bankruptcy Code. It is difficult to understand because a lot of its policies are based on things from outside of the statute, but I want to tell you a few things. One, it has exemptions, and exemptions state by state vary quite a bit. California's are pretty good. Other states have pretty good ones. Some states, particularly in the South, have lousy exemptions. Florida, of course, has the unlimited homestead exemption. You got to watch out. Everyone says, oh, I'm just going to move to Florida and I'm going to buy a $10 million home and it'll be exempt. Not correct. There is a provision in Section 522 that says if you have not been living in that in the jurisdiction where you file your bankruptcy, Florida, for at least 730 days, then the debtor must use the exemptions of the prior jurisdiction. So if you move from Tennessee, which may have a very minor homestead exemption, to Florida, you better wait the 730-day period. IRAs are exempt. And by the way, sometimes you see IRAs that are shoddily set up. They're not properly set up because the debtor's playing games. There's some ways to work around that. If you have an inherited IRA, they're not exempt. There's a recent Supreme Court case out on that. So if the debtor inherited an IRA from mom or dad and then files a bankruptcy, those monies are not exempt. My time clock tells me that I've got only a few minutes left, so I'm going to push along, and let's go to the automatic stay. The automatic stay is something which started actually as something to protect creditors, but it's really evolved to protect debtors and their assets. It protects pretty much any asset of the debtor. However, in Section 362B, there's a list of, 25 to 28 different things that are not protected. For our purposes, we start with the assumption that the automatic stay protects all assets of the debtor, and that if we or our clients go after any assets of a debtor during a bankruptcy without prior court approval, or perhaps a comfort order, we're likely to be sanctioned by the court. Under 362B, which is where it talks about what assets are not protected, as I said, it is a long, long list. And I just want to mention to you that just because you file a bankruptcy, if you've got a Medicare license, that doesn't, a license to, to charge Medicare and get reimbursement for services, that can be cut off. If you've got a credential, I'm sorry, not a credential, if you've got an accreditation as an institution of higher learning, that can be removed, that can be canceled, excuse me, under Section 362B. Look, well, let's spend just a minute on asset protection and the automatic stay. The automatic stay doesn't protect assets that are not property of the bankruptcy estate. Easy example, company files a bankruptcy and its principal has given a guarantee. His or her guarantee is valid and is no action against the guarantee is stopped because of the bankruptcy filing. The guarantor can be held liable in a non-bankruptcy court during the bankruptcy case. So what do? If you have the right facts, you in effect extend the automatic stay to protect the guarantor from lawsuits. With the right facts, and if you're in the right jurisdiction, and I think that's pretty much every jurisdiction in this country, you can get that, you can in effect get an injunction that extends the stay to the non-debtor and the non-debtor's assets. It's a wonderful negotiating tool. Another thing you can do is you can bring the asset into the bankruptcy estate. There are different ways to do that. Another thing you can do is try to extend the automatic stay, in effect, an injunction, a temporary injunction, to protect the guarantor or the third party's assets and the third party after the plan is confirmed. Difficult to do, it's possible to do, and the beauty of it is, let's say you have creditors who are really unhappy with both the debtor and the guarantor, and if you get this injunction after the plan is confirmed, you can stop them from coming after the guarantor so long as plan payments are being made. That might be 5 years, it might be 10 years. It gives a lot of time to do some real planning. Wendy has asked if an SGLI inheritance placed in an Roth IRA is exempt, I'm going to ask you to contact me directly by email or coming up to the page with my email address, and let's talk about it. I've got to get to fraudulent conveyances. I'm sorry. Fraudulent conveyances, most of you are familiar with. The concept is that a transfer of assets may be done with an actual intent to defraud, hinder, delay, defraud creditors, or a constructive transfer is a fraudulent conveyance. The rules in bankruptcy are substantially similar to those outside of bankruptcy. And this is one of the big places where bankruptcy trustees make money. They make a lot of money recovering assets that were transferred and recovered as fraudulent conveyances. Let me point out one thing to you, and Jacob touched on it, where a debtor creates a self-settled trust, and the debtor, in the 10 years before the bankruptcy is filed, transfers an interest of the debtor in property to the self-settled trust. The bankruptcy trustee can undo, with the right facts, that transfer. So let's go back over that. 1, debtor creates a self-settled trust. 2, in the 10 years before the bankruptcy is filed. 3, the debtor transfers an interest of the debtor in property to the self-settled trust. If it otherwise meets the requirements of a fraudulent conveyance, it can be undone and recovered by the trustee. It's a bit sobering to realize that you did something 5 years, 9.5 years before the bankruptcy was filed, and it could be undone. Again, this goes back to careful asset protection work, because you're not going to be talking to me 9 years before you file a bankruptcy, but you could be talking about you could and should be talking about asset protection with an asset protection attorney like Jacob. That's fraudulent conveyances. I just want to point out to you, take a minute, look at the slide. I threw this in. Businesses, companies make mistakes on the road to bankruptcy, and here are 10 typical reasons why companies fail and need a bankruptcy. And briefly, just going on to the next slide, you can see 18 examples of how and why companies are on the road to bankruptcy. In other words, how they fail. And Wendy emailed back, yeah, Wendy, you've got a serious question that's going to take some time. And so if you'd email me, I'd really appreciate it. Jacob, I'm going to make 1 or 2 closing remarks, and then I'm getting off and letting you take over. And so that's going to be fun figuring out how, oh, I see, I stopped sharing. So I'm going to stop sharing now. And I am basically going to say to you that bankruptcy is a real serious business. It's real serious, like asset protection work. It has to be done carefully, in measured ways. The most difficult bankruptcies are where there is no planning, especially no asset protection planning ahead of time. And now I've got to figure out how I'm going to sign out, and I'm sorry to say this. Jacob, I'm hoping you can take over from me.
Certainly. Thank you, Stephen. It's a wonderful presentation. I enjoyed it. I've learned stuff, which I always appreciate. So we have a couple of minutes remaining. So I want to make a couple of, first of all, a couple of practical remarks kind of to tie it all together, and then a couple of housekeeping items that we need to get to. So first of all, a question that I get asked very often is, when should I go to see Stephen Fox, and when should I be looking at bankruptcy, versus when should I be looking at doing asset protection planning and speaking to Jacob or someone in my practice area. So that's a very interesting question, comes up all the time. And as you'd imagine, it's the same set of folks who come to Stephen and who come to me, right? These are people who have a debt that they cannot pay or do not want to pay, or maybe want to pay a lot less than what they are otherwise supposed to pay. So they either are looking to protect assets or they're looking for to file for bankruptcy. So, I believe that the distinction is the following. Someone who has assets often should not be filing bankruptcy, right? Because the assets become part of the bankruptcy estate and are used to pay off creditors. Now, maybe in Chapter 11 it works a bit differently and a payment plan can be set up. But Chapter 11s are a bit more unusual for individuals and tend to be fairly expensive. So generally speaking, if you have assets, you should be seeking asset protection. You also should be seeking, I think, asset protection and not bankruptcy if for some reason you do not think, or your lawyer does not think, you will be able to get a bankruptcy discharge. Maybe because of certain conduct you engaged in, or certain transactions you've engaged in. So we look more to kind of these state court, state law type asset protection measures. If you have no assets or little to no assets, perhaps bankruptcy is the best option because it does give you that fresh start. It gives you a clean slate. Think about it, with asset protection planning, even if I can make assets entirely unreachable, which, as I mentioned earlier, is usually, rarely the case, even if I can make assets unreachable, do you want to live with the judgment hanging over your head for practically the rest of your life in California, right? In California, how long is a judgment enforceable for? 30 years maybe, right? Maybe more. So if you want that clean start, you need bankruptcy and not asset protection. What we do sometimes, though, is when we know that a client will have to file bankruptcy protection for whatever reason, but they cannot do it yet, perhaps we can set up some asset protection structures to sort of keep creditors at bay, keep creditors from getting their hands on our client's assets with the anticipation of filing bankruptcy. And I will tell you, both based on Stephen's discussion and just some prior knowledge, then that when we know that a bankruptcy will be filed, what we do to protect assets will be very different than what we do when there is no bankruptcy on the horizon. When there is no bankruptcy on the horizon, we can do whatever we want to, right? And it's, again, that very practical consideration. It either will work or it will not work. If a bankruptcy will be filed, now you have a bankruptcy court looking at everything we have done. You have a bankruptcy trustee examining every detail of what we have done. And certainly someone like a bankruptcy trustee will be a party that's very knowledgeable as to how all of these structures work. They're very knowledgeable as to fraudulent transfer laws. And they're usually fairly aggressive in pursuing assets, right? Because they get a piece of the action. So a bankruptcy trustee for us is a very difficult creditor to deal with. And so if I know that a bankruptcy will be filed at some point, we will always bring in Stephen or one of his colleagues to get that done. So let me ask you, there were a couple questions that came up, and by the way, if you want to ask questions, the Q&A is still open. So a question from Stuart. I remember a Ninth Circuit decision that a debtor who placed assets overseas and refused to bring them back when ordered to do so by the court was held in contempt of court. Yeah, there are a few cases like that. I think Stuart is referring to the infamous Anderson case out of San Diego, where a debtor was held in contempt of court for failing to repatriate assets to the United States. I'm somewhat intimately familiar with that case, and I will summarize it the following way. The debtor could have brought the assets back to the United States. He just chose not to, knowing that he will go to jail on a coercive contempt charge. And the debtor in that case ended up spending about 6 months in jail, and then he was released. And to this day, that debtor has about $30 million in his offshore trust, which is something that commentary usually does not address. So the asset protection worked, but of course we never want our clients to go to jail. We never want to place them in a position where they would have to go to jail. But by the same token, it is often a binary choice. Choose to do nothing, choose to do something. Whatever you're doing might not work, but we know with 100% certainty that doing nothing will not work. As the great Wayne Gretzky used to say, 100% of the shots you do not take do not go in, right? So we keep trying. Okay, couple housekeeping notes in the remaining minute. For those of you who are attorneys, you should be getting CLE certificates for attending this presentation. If for whatever reason you do not get your CLE certificate, let's say in the next day or so, please email us and we will get that certificate to you. If you'd like a copy of the slides and the kind of more extensive written materials, we're happy to get those to you as well. We can distribute that to you guys. And then if you logged in late, I believe the link to the presentation will continue to be available to you and you will be able to listen to it later. We're also putting up this presentation on our website, on the Alliant website, alliantlaw.com. It will be on our YouTube channel, so you can easily search it for like asset protection, bankruptcy, or Stephen Fox, Jacob Stein, and pull it up. With that, thank you everyone for attending today's presentation. We have many more presentations scheduled on various topics in the coming months. And I'll see you around. And thank you again, Stephen. It was a great presentation.
Thank you.
Take care, everyone.